Welcome, and thank you for joining us for today's webinar hosted by the Hoover Institution Center for Revitalizing American Institutions. My name is Erin Tillman, and I serve as an Associate Director at the Hoover Institution, and I'll be today's webinar host. Before we begin, let's review a few housekeeping items. Today's session will consist of a 30-minute discussion, followed by a 20-minute question and answer period. To submit a question, please use the Q&A feature located at the bottom of your screen. While we may not have time to address all questions, we will do our best to respond to as many as possible. A recording of this webinar will be available on the RAI event webpage at the Hoover website at hoover.org/RAI in approximately 3 to 4 business days. The Center for Revitalizing American Institutions, also known as RAI, was established to study the reasons behind the crisis in trust facing American institutions, analyze how they are operating in practice, and consider policy recommendations to rebuild trust and increase their effectiveness. RAI works with and supports Hoover Fellows, as well as faculty, practitioners, and policymakers from across the country to pursue evidence-based reforms that impact trust and efficacy in a wide range of American institutions. When we say institutions, we mean governing and judicial bodies at the state, federal, and local levels, as well as non-governmental civil society organizations, such as media, nonprofits, and foundations. We also attempt to understand public opinion and behavior, particularly as it relates to electoral accountability, and are making investments to improve civic education in both K through 12 and higher education settings. RA operates as the Hoover Institution's first ever center and is a testament to one of our founding principles, ideas advancing freedom. Since 1919, the Hoover Institution has sought to improve the human condition by advancing ideas that promote economic opportunity and prosperity, while securing and safeguarding peace for America and all mankind. Today's webinar kicks off our 2025-26 series, Reimagining American Institutions. Throughout the year, the first Wednesday of each month, we will feature speakers who are developing innovative ideas, conducting groundbreaking research, and taking important actions to improve trust and efficacy in American institutions. Our goal is to build awareness about how we can individually and collectively revitalize American institutions to ensure today our country's democracy delivers on its promise. It gives me great pleasure to introduce today's moderator, Eugene Volokh, the Thomas Siebel Senior Fellow and an affiliate of the Center for Revitalizing American Institutions at the Hoover Institution. Eugene is one of our nation's leading legal scholars. He's doing his 30th tenure as a faculty member at the UCLA Law School. He taught First Amendment law, copyright law, criminal law, tort, and firearms regulation policy. He's a member of the American Law Institute and the American Heritage Dictionary Usage Panel, and the founder and co-author of the Volokh Conspiracy, a leading legal blog. His work has been cited in more than 350 court opinions, including 10 Supreme Court cases, as well as over 5,000 academic articles. He also filed briefs, mostly amicus briefs, in over 200 cases and has argued in 40 appellate cases in state and federal courts throughout the country. We are thrilled to have Eugene leading the Hoover Institution's program on free expression and grateful that he has agreed to lead today's conversation. I'm also pleased to introduce today's guest, Orin Kerr. Orin Kerr is a senior fellow at the Hoover Institution and professor at Stanford Law School. He helped found the field of computer criminal law, which studies how traditional legal doctrines should adapt to digital crime and digital evidence. He is widely considered a leading authority on Fourth Amendment, and Kerr has written more than 75 law review articles in addition to authoring casebooks and treatise chapters. His latest book is The Digital Fourth Amendment, and his scholarship has been cited in more than 400 judicial decisions, including several U.S. Supreme Court decisions. Before entering academia, he was a trial attorney in computer crime and intellectual property at the U.S. Department of Justice. He served as a clerk to Judge Leonard Garth of the U.S. Court of Appeals for the Third Circuit and Justice Anthony Kennedy of the U.S. Supreme Court. Thank you, Orin, for being with us today. And now I'll turn it over to Eugene to begin today's conversation.
Great. Erin, thanks very much for the introductions. Orin, thank you so much for joining us on the webinar. Thank you for joining us at the Hoover Institution.
Great to be here as to both.
Such a pleasure to have you as a colleague at this institution level. We have been co-bloggers for over 2 decades. That's 140 in blog years. So it's always a pleasure to be on with Orin. And it's particularly interesting to talk about the subject because, computers, I hear they're going to be big. So it's important to think about how our constitutional norms apply to various fields, including especially the Fourth Amendment. And as in general with lawyers, it's important to think about it at two levels. One is sort of the conceptual level. How should we think through the big picture of what it means to have protection against, say, searches and seizures and such with regard to computer technology? Of course, it's also important to figure out, like, what do the actual rules actually say? What do courts do when faced with the new technologies? How do precedents from the pre-new technology side, how do they apply, or how can we expect courts to apply them? I like to think that successful legal academics work at both levels, both the theory level and the doctrine level, but law being a practical discipline in many ways. And Orin has been extraordinarily successful at marrying these two. So without further ado, just tell us a little bit, the digital Fourth Amendment, privacy and policing in our online world. What should people who don't know much about this area of the law, what should be the basic things they think about when they hear about some question about searches of computers, searches of cell phones, searches of the internet, and the like?
Yeah, so the first thing to think about is a practical one. Digital evidence is everywhere. You probably have a cell phone right next to you. You're probably watching this webinar on a computer, and these devices store an incredible amount of information, which the government might be interested in collecting to prove criminal cases. Computers store lots and lots of information, and they store it in new places and in new ways. And the government loves to collect this information because they can use it in powerful and sometimes counterintuitive ways. And an interesting example of this, there was a case in Pennsylvania from 2 or 3 years ago of a man who broke into a woman's apartment to commit a robbery, to burglarize, her apartment. And he happened to have a cell phone with the camera on. He was using it as a flashlight at night. It was 3 a.m. And the government helped prove the criminal case by searching the phone and showing that the phone's camera app was on at the time of the burglary. That was just one piece of evidence that they had. And so your phone, it turns out, keeps a record of exactly when your app that controls the flashlight was on. Your phones keep an extraordinary number of records, type of records, precision of records. And so when the government searches your phone, they're not just searching, a thing in your pocket. They're searching your entire digital world. It could have all of your text messages, all of your emails. And so the first thing to just think about is that we're in a new world of digital evidence collection. The government isn't just looking for eyewitness testimony and physical evidence, grabbing the drugs in a drug case. They might prove a drug case by going to Google and saying, Google, give us the records about where this person was to help prove the drug case. So there's a challenge here, which is that if you apply the old Fourth Amendment rules, this is the prohibition on unreasonable searches and seizures, if you apply those old rules kind of rotely, just say, hey, we have this rule, apply the rule, you sometimes end up with a dramatically different effect of the rule because the technology has so dramatically changed. And there are a lot of examples of this, I think, in the history of the law. But the basic takeaway of this, I think, should be we just have a new world of digital evidence, new kinds of evidence in new places held by internet providers on our phones. And the old traditional constitutional rules often create really quirky results when applied to these new forms of evidence collection. And you have a choice, basically. Should the Constitution follow the old rule, or should we try to maintain the role of the Constitution to try to adapt the old principles for the new environment? And my book is basically an argument for why we should adapt the principles and maintain the role of the Fourth Amendment, not the rule, and how we might do that in the new world of digital evidence.
Got it. So that makes a lot of sense. But how does it play out in practice? Can you perhaps point at some Supreme Court decision that you think has, or maybe lower court decision that has correctly adapted to new technologies, and maybe one that that you think either just too woodenly applied the old existing rules, or maybe just was so deer in the headlights that just couldn't figure out what to do and just did something wrong.
Yeah, so a great example of a good decision, or one that I think uses the correct method and approach, is the U.S. Supreme Court's Riley versus California, a case from 2014, involving a rule called the search incident to arrest doctrine. So this is a rule that when the government arrests someone, they can search everything on their person. And it goes back to the common law. It's hundreds of years old. And in a 1973 case called Robinson, the Supreme Court said, listen, when they arrest someone, when the officers arrest someone, they can just automatically search everything on them. No need for it in a particular case, no limits on that. Just search everything on the person. And that was a person who was pulled over for driving without a valid license. And the officer searched him and found a crumpled up cigarette package, opens up the cigarette package and finds drugs inside. And the U.S. Supreme Court says, listen, we have this search incident to arrest rule. It serves purposes of evidence preservation. It serves role of officer safety. And we're going to say we don't look case by case at whether those interests are served. Instead, we just have a general rule, and there will be some cases that further these interests and some that don't, but we just need a bright line rule. And so that's the rule that emerges in 1973. And then people start carrying digital devices. Initially, it's like pagers that store 5 phone numbers, but pretty soon it's cell phones, flip phones, and then smartphones. iPhones come around in 2007. And by 2014, most American adults are carrying cell phones, smartphones, iPhones. Just extraordinary change in technological assumptions occur. And the Supreme Court, the law enforcement loves this rule. Basically, they arrest someone for any offense and search their iPhone and find all of their text messages, emails, location history, everything. And it's an extraordinary expansion of government power. The Supreme Court unanimously in Riley says we will not apply the search incident to arrest doctrine to cell phones. Why? It's no longer reasonable under the Fourth Amendment. It's not a reasonable search to search a cell phone without a warrant whenever an arrest is made. The nature of a cell phone search is just completely different from searching someone's pockets, from opening up the crumpled up cigarette package. The scale is dramatically larger. The purposes are dramatically different. And we're not going to allow basically a search of someone's entire digital world just because it happens to be on their person now. The rule did not foresee this tremendous change in where evidence is and how much there is. In part of a lot of this driving this is that the amount of data on someone's cell phone is just extraordinary, just libraries worth of information. So 9-0, the Supreme Court says search incident to arrest applies to physical evidence, but does not apply to digital evidence. So that, I think, is a good example. It's an approach which I call in the book equilibrium adjustment. That is trying to keep the Fourth Amendment's equilibrium, the sense of like the government should have enough power to investigate cases, but not so much power that they can abuse these authorities. And you try to sort of maintain that role as technology changes. So that's, I think, a good example. An example that I think is problematic, let me point to the Fifth Circuit had a ruling in a case called United States versus Smith just last year on whether databases can be too large to search with a warrant. And this is a case involving geolocation records. Google, it turns out, had a huge database with everyone's records. And the question in the case was whether a warrant can be used to search through the records. And the Fifth Circuit said, basically, that database is too big to search. It's a general search under the Fourth Amendment. You have to think through, like, it's basically searching the entire world to try to find the particular evidence through this massive database. And I think the problem there is the court is thinking, has an incorrect model for what a scan through a database means. They're thinking of a scan through a database like an officer going house to house looking for all of the data, instead of just a tool that's looking for a positive hit and gathering that data. So that becomes kind of an issue of modeling what it means to search. And under that rule, basically, a lot of searches just can't happen, even with a warrant under the Fourth Amendment. And a bunch of lower courts have since disagreed with the Fifth Circuit, but that's an example of one that I think went in the wrong direction.
Got it. Well, that makes a lot of sense. So let me ask a question that I'm sure you've gotten before. I mean, you might think that it's useful question or not, but I do think this is what a lot of lay people are interested in. So we hear all of this talk about originalism and focus on original meaning. And we know that in the Fourth Amendment context, the court has often looked at original meaning. And I think justices, both on the left and the right, have appealed to the framers and appealed to the framers' judgment as to the Fourth Amendment. Of course, Fourth Amendment also, unlike other provisions, has this word unreasonable searches and seizures, as well as other words like papers and effects and such. So one question is, how do we think about words like unreasonable in the when it comes to originalist inquiries? But in any event, rightly or wrongly, also many justices say that they are originalists and want to look at that. How does one think through original meaning when it comes to technology? The framers were well aware that there was technological change. They knew that they were living in a time of immense technological change. They were provided in the copyright patent clause for it to be an engine of technological change, but surely they didn't expect cell phones. So how does one think, if at all, about the Fourth Amendment and originalism in an era of computers?
What makes this topic really interesting to me is that you get to the same result and you get actually the same approach, whether you're thinking through it from an originalist standpoint or a living constitutionalist standpoint or a pragmatic standpoint, in that the history of the enactment of the Fourth Amendment suggests the enactment of this broad principle, which you then have to maintain over time. And so there's no, there were some common law specific rules as to what government powers were that maybe the Fourth Amendment was understood to adopt in 1791 when it's enacted, but it's drafted in this very broad way using broad phrases, some of which were sort of not well known, like unreasonable searches and seizures. That phrase had been introduced only a few years earlier in the Massachusetts Bill of Rights. And so you still have this problem of, if you're going to maintain the framers' commitment to the Fourth Amendment, what's the principle at stake? And that suggests to me a technology independent framework is needed. And a great example of this is the work of Justice Antonin Scalia, of course, prominent originalist Supreme Court justice who passed away in 2016. During his time on the court, he wrote a lot of opinions trying to basically take the Fourth Amendment and put it into an originalist framing. And that includes very much this idea, this equilibrium adjustment idea. And I think a great example of this is Kylo versus United States, a case from 2000 on thermal imaging devices. So the government gets a tool, gets an infrared thermal imager. That is basically a camera that measures infrared light. And they park a car across the street from a suspect in a drug case, and they point the thermal imager at the suspect's house and see that the suspect's walls are hot, which they use as evidence that he is engaged in growing marijuana in his house because the heat lamps are generating so much heat. And the question is whether the use of the thermal imager is a search. And Justice Scalia says it's a search because you need to interpret the Fourth Amendment to preserve the privacy protections that it had at the founding. You need to make sure what is a search sort of reflects the state of technology and recognizes the role of the Fourth Amendment, not the rule. And so you need to, basically, it's almost like you need to work backwards. If you don't interpret the Fourth Amendment that way, then the government comes up with technologies that can see through walls, and suddenly the Fourth Amendment doesn't mean anything because the government can just see through your walls. They don't need to physically enter your house. You can't interpret the Fourth Amendment that way because you need to maintain the degree of privacy that existed when the Fourth Amendment's enacted. And so that's what's interesting to me about that is it's an originalist framing. Fourth Amendment adopts a principle. We need to maintain the principle that leads to an approach, which is that you kind of have to look to the technology and maintain the role of the Fourth Amendment and sort of maybe enact new rules for new technologies in an originalist framing. And justices across the ideological spectrum actually all seem to agree with this method. It's a rare point of agreement among Supreme Court justices. They're all kind of on board with this, maintaining the role and updating the rules, whether they're originalist or not. So they actually all end up kind of being in the same on board this goal, and then how to achieve that goal becomes the tricky part.
Got it. So that's very helpful. Let me now turn to a much less historical question, just more a functional question. So searches and seizures are potentially very dangerous, harmful to freedom, harmful to democracy. Absence of effective law enforcement is potentially very dangerous, harmful to freedom, harmful to democracy. So there are lots and lots of situations where, there need to be searches and seizures. We feel there ought to be some restraints, but the question is to what extent, of course. And the answer is unreasonable, but what's reasonable, what's not, doubtless will turn on how much one is worried about certain kinds of crime, let's say, at least to many people. You might say there are general principles about what's reasonable and what's not, so that it's generally unreasonable to search without a warrant, except when it is reasonable. But one question is why? Why should we think that? So again, one possibility is just sort of maintain the historical pattern. Maybe that's right. Maybe that wouldn't require us to return to these first principles. But still, in some situations, I think we probably would need to look at first principles and trying to figure out when there is potentially huge public safety benefit, but also possibly huge privacy sacrifice. What do we do? What do we do, and how do we think through things? One possible answer, of course, might just be, well, you look at the precedent, and for many, that's the job of the lower court judge. That's the job of the prosecutor and the defense lawyer is to try to follow it. But at some point, either sort of at a social level or at the Supreme Court level, there need to be some decisions about this. Do you have some broader sense of how to think through that, given that kind of categorical privacy at all costs? People have said they're free speech absolutists. I don't think there ever were any free speech absolutists, but you can imagine that. It's very hard to imagine a search and seizure absolutist. No searches, no seizures everywhere, right? But likewise, you'd think that probably you'd want to have some constraints. So you don't want to say law enforcement at all costs. What's your general sense of how to think through these kinds of problems?
So Fourth Amendment law is always going to be a blunt instrument to do that. I mean, we're really talking about kind of, as you framed it, it's almost like an optimization problem, right? You don't want to have too little.
So much in life is.
You don't want to have too much law enforcement. Just right is sort of the
Right.
goal. And everyone's sense of what is just right will depend. As you suggest, some people are very law enforcement oriented and will have a sense that like lots of policing is good, Rehnquist. And then you'll have some justices that are very suspicious of law enforcement and think law enforcement usually is doing these things in bad ways or often. And so they want very little law enforcement. And we kind of think of who that is. That's Justice Douglas, maybe historically, or on the current court, maybe more like Justice Sotomayor. At least to some degree. And so we'll just have different senses of this. And to some extent, you could say, well, this is where you get 5-4 cases on the Supreme Court. They disagree where the line is, and whoever has 5 votes wins is maybe the kind of actual practical answer. I think, though, what the Fourth Amendment is going to do is going to keep that choice within certain bounds. Ideally, you would have legislatures step in and draw what they see as like the perfect line, according to at least the legislative view. Whether legislatures get it right or not is another question. But we're dealing with a blunt instrument of the Constitution where they're not going to be. I think I approach this to some extent as a question of what your goals are. If the goal is to get to the perfect rule, you're probably going to be disappointed. You're going to study this area of law, or really probably any area of law, and think, well, this is not quite right. On the other hand, if the goal is to avoid really bad outcomes, that's where I think these approaches actually can be helpful. So an example of this, let me go back to Riley, the case of searching cell phones incident to arrest. Whether you agree or not that a warrant requirement for searching any digital device on arrest is the right rule, you probably agree that the prior rule, which was that the government could search any digital device, any cell phone without any limit, anytime they arrested anyone for anything, that was bad. And so to some extent, I think what the Fourth Amendment is doing is it's avoiding the clearly those extremes, and trying to focus things on the center. You often don't know ahead of time what the crime is going to be, why the government is going to be investigating a case. Is this a important law enforcement investigation? Is it state? Is it federal? All those kinds of things. It's going to be a technology. You're going to have to create the rules when the justices are trying to interpret the Constitution. They don't know in what setting that rule will be used. And so it's a blunt instrument in which you try to avoid the bad rather than try to hit the ideal.
Got it. Well, that makes a lot of sense. Let me close with one other question, again, just because I think it's on the minds of a lot of people in the audience, because I think it's the minds of a lot of people when they hear about it. What's all this with the exclusionary rule, they say? They say, well, okay, so a search may be unreasonable, and that could be bad. Maybe there should be punishment. Maybe there should be liability. But if it uncovers evidence, and that is obviously often the case with electronic searches, if they do illegally search your cell phone and they find this evidence, why should the truth-finding process be undermined because of this mistake or even willful violation by the police? Why should justice not be done? Why should justice not be served? Why should the criminal go free because the constable had blundered? That's the old question. My understanding is at different times in American history, there have been different views on this subject. Today, the exclusionary rule exists, although with various exceptions. And once upon a time, I think a conventional wisdom is at least many states did not accept it. Then for a while, it seemed to be in its ascendancy. Now it's sort of somewhere in the middle. What's your sense of the exclusionary rule, both how it applies to electronic searches and otherwise? And then I think we will turn to questions.
Yeah, so I think the framework of the exclusionary rule is basically premised on something like an economic view. Like, you need to think ex ante rather than ex post. You need to think, how do you avoid constitutional violations?
Can we think in English, please, instead of Latin?
Absolutely. You need to think through what are the incentives to avoid violating the Constitution, rather than in a single case, what do you do now? So the goal of remedies should be to prevent constitutional violations, not to give people, here's $1,000 for your constitutional rights being violated. And so the Supreme Court recognizes or adopts the exclusionary rule in 1914. This is at a time when the Fourth Amendment does not apply to the states at all. So the original exclusionary rule is federal only, and it only becomes something that applies to the states in the 1960s. The challenge, actually, the current Supreme Court doesn't like any Fourth Amendment remedies. There's no civil action, not much of a civil action if your rights are violated by federal agents. There's only a little bit of a civil action if your rights are violated by state law enforcement, because they're like, well, we don't want to, you're going to sue the police. These nice police officers, and you're going to sue them and take away their, that's terrible. And so there are no great answers for how Fourth Amendment rights should be violated. I think the goal should be a remedy system that prevents the violation in the first place. The thought of the exclusionary rule is that if you tell an officer, listen, you can do this thing that violates, you can break into that person's house without a warrant, but whatever you find, it's actually not going to be usable against them, that's at least some sort of deterrent to make them go, I should probably get a warrant. That's the thought. It's hard, though. I think it's a continuing conversation as to what are the right remedies under the Fourth Amendment, because really no one likes any of the remedies, and yet a rule with no remedies isn't much of a rule.
Well, that makes a lot of sense. We have some questions now. Let's go through this. So one question just came in. much personal digital data actually resides in a third-party platform rather than just on the personal device. Can you talk about the competing concerns and questions that apply in situations when there is an attempt to get information from this third party?
Great. So this is actually about a third of the book is on this question. What do you do with remotely stored data and the fact that as the person said, a lot of your data is stored remotely. And so here, I think, again, the goal should be to recreate rules that resemble the in-person rules and traditional sort of rules. Mapping the Fourth Amendment onto the network environment requires, in part, sort of building a lot of analogies. Like maybe your email and your text messages are like your mail or like things in your house. Then there's records about what you did. There's like, what address you used to sign into account. Maybe that's like something you would see if the officers watched you in person, they would see where you went. Maybe that's kind of equivalent to that. And so I argue in the book that basically you should start by trying to figure out digital information has a physical equivalent. Start by trying to match the constitutional rules from the physical to the digital to try to have information equivalence. But then you have to ask, well, are these really equivalents, or is this just a totally new environment? And the Supreme Court's 2018 decision in Carpenter versus United States is an example of this. That was a case involving the records that your phones create whenever they're logged into the network, whenever they're connected to the network. And it allows the government to create a rough location history as to where you were because your phone is on, it's connecting to a local tower, and then the phone company has records like basically, hey, Kerr was in this neighborhood because his phone was there. And the Supreme Court says that those records are protected under the Fourth Amendment and that that's just a totally new kind of record. We need to kind of figure out the category for those new records. And the court says this is just something totally new. We've never seen anything quite like this. And basically, we don't want to give the government a windfall and just give the government warrantless tracking ability, so that we're going to require a warrant in order to maintain the role of the Fourth Amendment. That's, again, this kind of equilibrium idea. And so the network issues are really important and a good part of the book. My end result is that the contents of records should be, the contents of communications should be presumptively protected. Non-content records usually not protected, but actually there's like a category of middle ground of new records, kind of like the Carpenter approach, that should be protected. So that's a hugely important issue given how much of our data is not with us, but is out there in the cloud.
Makes perfect sense. Thanks very much. So there was another question that came in early on, and it asked how all this interacts as to the federal government with presidential immunity. And I think maybe it would be good to also throw in other immunities. So the question is, given the Trump v. U.S. case, which protects the executive immunity, do you feel the Fourth Amendment no longer applies to the president and the DOJ? I think that's something of an overstatement, but let's throw in some other immunities. There is qualified immunity. There are other kinds of immunities. There's possibly some national security type immunities. What's your sense of, as a functional matter, to what extent Fourth Amendment rights are constrained in some measure by the presence of various immunities?
Yeah, so presidential immunity doesn't play much of a role because it's really just the president, at least from what we know of the Supreme Court's recent ruling. And so what we're dealing with here is much more individual officers, DOJ officials, and they would still be subject to remedies. But a lot of remedies for Fourth Amendment violations have some sort of partial immunity, whether it's something called qualified immunity, which basically says the right has to be clearly established. It has to be an obvious violation. It's not a close call like, wow, I can't believe they did that. That's when a lawsuit trying to recover money from the government, from the officer, might work. But actually, the exclusionary rule also has something very similar, the good faith exception. The basic idea behind all of these is like, we don't want to punish the government if they were close to complying with the Fourth Amendment. We only want to punish them if they really, really, maybe they knowingly, intentionally violated the Fourth Amendment. They're sitting outside the house saying, this is going to violate the Constitution, but we don't care. That tends to be where there's a remedy, and sometimes it's to recover money, sometimes it's for the exclusionary rule. But these immunities limit the scope of the remedy available to people. And, the challenge is when you pull back the remedy and you say it needs to be a really clear violation, well, the officer is standing outside the house and says, maybe I need a fourth. I probably need a warrant, but I'm going to do it anyway. And they probably won't be sued, or they won't have to pay out under qualified immunity. So the stronger the remedy, the stronger the deterrence, and vice versa. So it's a continuing difficult question.
Got it. Very helpful. Thank you. So here's a specific question by one particular corner, although an important corner of Fourth Amendment law. What about the confiscation, it is said, but probably the real question is, I think, seizure for purposes of search of cell phones when a person enters the U.S. from a vacation abroad. So an American person comes back to the U.S. From abroad. What are the powers that the government has?
So this is one of the 10 chapters in the book, what to do with the border search exception. The traditional border search exception says basically the government can search anything crossing the border, including your cell phones and including your laptops that you happen to have with you, basically without limit. And lower courts are trying to figure out, how do you apply this framework, this digital is different kind of Riley versus California framework, to digital devices. And some have said you follow the traditional rules, still no limits. Some have said there are some limits. And I argue in the book that the border search exception should not be applied at all to digital evidence, much like the search incident to arrest exception is not applied at all in Riley. So basically, you go through the rationales and you say, listen, these are very physical rationales for why property should be searched at the border. They really don't apply to digital evidence. And so the digital rule should be different, I argue. The question of seizing devices is interesting because a lot of searches are preceded by seizures. That is, they grab the device and then they search it. There was a Fourth Circuit ruling last year saying that just seizing the device requires suspicion, in addition to searching the device requires suspicion. So courts are trying to figure this out. They realize it's just pure happenstance that everybody's like on their cell phones all the time. Therefore, when they're on their international flights, they're on their cell phones. And so they have these very powerful devices with lots and lots of evidence. So how much to cut that back? I think basically entirely. But how much should courts cut that back is a really important question here that lower courts are dividing on. And I have a chapter in the book specifically on that.
Great. Very helpful. Thanks. There's a question. What are the boundaries of the Fourth Amendment's protection with regard to data collected with respect to national security? Are there special rules for national security, or is it all bets are off? Is it a special procedural framework? What is it? What are the rules governing this? It's just a corner of searches. My sense is the great bulk of searches are non-national security, though maybe we don't know, but a very important corner.
Yes. So national security searches end up being kind of considered in their own category for two reasons. One is there's some special sense of like, well, if it's a national security search, that's a special reason for surveillance. So that maybe we have sort of greater government powers in that setting. There's a totally different statutory regime. So there are laws passed by Congress that say, here's what the government can do in criminal investigations. Here's what the government can do in national security investigations. And there's a law called the Foreign Intelligence Surveillance Act, which has been amended many times, which goes back to the 1970s, that says, here's the regime for national security surveillance. Roughly speaking, I think you'd say the Fourth Amendment principles are similar. What is a search is the same. When there are searches and seizures reasonable, the government has sort of extra powers of reasonableness because of the national security setting. And then Congress's laws are quite different under this Foreign Intelligence Surveillance Act.
Got it. Great. Thanks very much. I wanted to throw in a question of my own. So historically, the Fourth Amendment has not applied to searches. We don't even call them searches, perhaps, but to observing things in public places. If a police officer is standing on the street corner, whether in uniform or out, and just sort of looking around, perfectly free to do that. And if he's searching the crowd for somebody, well, let's say that they're looking for a particular person, they're free to do that. And if in the process they see someone doing something suspicious, somebody else, that's fine too. Nobody needs a warrant for that. Nobody even needs probable cause. But these days, apparently, there are all of these technologies, everything from license plate readers for cars, but also just the facial recognition, which is shockingly effective, where in principle, you can imagine the government having facial recognition. Probably there are already places where it does have it, and it kind of looks everybody up, maybe even assembles a nationwide database, not just of people who go and like apply for global entry or whatever, but just because, again, they could take photos of people in public places and maybe harvest them from driver's license information and such. So really, you could have a situation where the government is constantly tracking where we are going, at least unless we're using very good disguises, just based on things that are visible in public without even having to, let's say, get information from private repositories like telephone companies' location information. Do you envision the Fourth Amendment having anything to say about that? Or is the answer still, when things are in public places, just because the police department has gotten very, very, very good at spotting people, doesn't create any new Fourth Amendment constraint?
This is very much a live question. Lower courts have divided on these issues, and there's sort of two different ways that they arise. One is in the context of what are called pole cameras, and that's basically just a camera on the top of a pole. Usually the government will like install a surveillance camera out in front of a suspect's house. Maybe they think that person is dealing drugs, and so they'll put up a camera on a telephone pole and watch the person, 10 hours a day. If there's ever any movement, they'll turn the camera on and it'll record what's going on. And the question is that a search? Is that different from, just an officer standing up on a telephone pole and watching? And then the other ones are the ones that you suggested, Eugene, sort of license plate readers, databases of lots of location information that can be queried. This is starting to come up in criminal cases. The government wants to show where someone was. They want to show the person was near a robbery, and they can show that the person's car was near a robbery, or they just want to find them. This is probably coming up in more of the cases where they query the database. They might say, hey, if you see the license plate, let us know where the person is. And they say, oh, look, the person's over on that bridge. Let's go there now and we'll find him. And is that a search or not? This is that same question of, okay, well, this is a old rule is visual observation is not a search at all. Under that rule, the government's power is expanding. Should there be a new rule that cabins back the government's power to kind of restore the limit that used to be there under the old rule that just was a matter of lack of technological ability to conduct more surveillance? And courts are divided on this question. Most courts say that at least with the fixed camera, the sort of single camera, that's pretty similar to visual observation and not something that triggers a search. With the automatic license plate readers and the broader databases, a lot of courts have started to say, well, if this was super comprehensive, this might at some point become a search, but the facts we have here are very limited, and they just, found the person that one time, and so that's not a search. The challenge here is where do you draw the line? With favorite academic question. And the theory that some have floated that has found in some lower court cases is what I've called the mosaic theory. That maybe as the government does lots of non-searches, it starts to create a picture of someone's life that is sufficiently invasive that it's like the equivalent of going into their home, and a mosaic is created that sort of gives the government a view of something such that a search should be identified. And this goes back to a case called Jones versus United States in 2012, where they tracked someone's car. They put a GPS device on a person's car and tracked him for 28 days. And Justice Alito, interestingly, wrote an opinion, concurring opinion, saying, well, it's not a search at first, but after you've tracked somebody for 28 days, you've learned a lot about them. And at some point in those 28 days, a search occurred, sort of started. And so this mosaic theory, I have a chapter in the book on whether that's a viable approach. And my own conclusion is it's just that can't be the way we do things. Maybe all uses of some kinds of cameras are a search. But to say, a little bit of surveillance is not a search, but a lot of surveillance starts to become a search. That line between a little bit and a lot is incredibly hard for judges to draw. It's basically, I think, something that just it's too easy for the government to manipulate. If the rule is 30 days, the officers will go 29 days, stop for a day, and then start again. And it's just too hard to do. But trying to figure out what do you do is scale is clearly a really important question with computers.
Well, it is indeed. It is indeed one of the key questions. I think we have time for maybe two more questions. So here's one. This is perhaps a practical question. Any advice for people who are concerned about government searches and who are using digital devices, which is to say all people are using digital devices. Some of them are concerned about government searches. Is there something that they can do to prevent, at least let's say, undue government searches? Let's assume someone who we think is a law-abiding person, but is worried that some of their data will get sucked up. Maybe some of it is going to be misunderstood, or maybe some of it will end up getting leaked or getting hacked or whatever else, and they want to minimize their exposure. Is there anything they can do, or is it just a lost cause?
So there are certainly a lot of steps that a privacy-concerned citizen can take to lessen the risk of threats of any outside threats, whether it's you're worried about a government officer or some local police officer,
or a foreign government,
or hackers, or whatever, all sorts of threats out there, and so. A lot of them are sort of the general computer security things that, update your operating system and, always keep that updated and, make sure you've got a good passcode on your phone. Don't use 1, 2, 3, 4, 5, 6 or your birthday, which are the most easily guessed passcodes.
I'm sorry. Could you hold on? I've got to do something.
So sort of basic computer security practices are the should be used whether you think the threat is the government or private actors, someone coming up to your phone and grabbing it. There have been a lot of concerns about whether you should whether you should have basically a passcode for your cell phone or biometrics. So biometrics is either like Face ID or a thumbprint reader. And in general, you have sort of greater rights to the extent you're worried about the government. You sort of have more constitutional protections through passcode entry than biometrics because of the Fifth Amendment privilege. I think it's sort of unlikely, practically speaking, to be an issue, but some people are concerned about this. So maybe biometrics is less privacy protective because someone can, I think probably the greater risk is, someone steals your phone and grabs it, grabs you and says, look into the phone. Easier to do that than to make you enter in a passcode. But so in general, probably those, good computer security is really the goal. It's not something legally specific.
And it pays dividends in many ways.
This has been a great conversation. Thank you so much, Eugene. Thank you so much, Orin. We appreciate
Orin, thank you very much.
Thank you, Eugene, for hosting. Appreciate it.
We appreciate the audience for your participation and great questions. If you're interested in diving in more in any of these concepts we discussed today, please feel free to purchase a copy of Professor Kerr's book by using the QR code that we're going to put on the screen. It's a great book, and obviously a lot of the chapters we discussed in today's discussion were referenced.
So does the QR code, does the dinosaur sort of suggest that this is commentary on the obsoleteness of modern Fourth Amendment doctrine, or?
It is very subtle. I'm glad.
Very subtle, very subtle.
We always appreciate the events team for your assistance in putting on these great webinars, and want to remind you all that this recording will be available on the Hoover event page in 3 to 4 business days. Our next webinar will focus on electoral reforms that address polarization and extremism and will take place on Wednesday, November 5th at 10 a.m. Pacific with Larry Diamond, Ned Foley, and Rick Pilds. I encourage everyone to visit our series webpage to sign up for the next session, access recordings of previous webinars, and subscribe to the RAI newsletter to receive updates of upcoming events. Hope you have a wonderful rest of your day, and thank you for joining.